I'm just gonna wait until Siri is back. Nothing. Yeah, okay. Yeah, I'll start then. So welcome everyone to this roundtable on the second roundtable of the day, where we will be asking why the anti-liberal counter-movement is interested in Norwegian type. This session is related to the same project as the former roundtable, so legitimacy challenges the children's rights and the child protection system. And also this is related to the former book project that was mentioned. On the European Court of Human Rights and Child Protection, where the case of Norway is of particular interest. And one of the reasons why we focus on Norway is in this book is exactly because of this anti-liberal counter movements, because they are increasingly being involved in the case of Norway and their child protection system in many different ways, so both informally and formally, actively engaging to criticize and contest the Norwegian child protection system. So to discuss this today, we are very fortunate to have with us two of the absolute top and foremost experts in the field on topics concerning legal mobilization and anti-liberal counter movements. We have Rachel Cichowski, and as you see, this is not a new Datta. It's our very own Siri Gloppen. So a short introduction of the speakers. So first, Rachel is a professor at the University of Washington, Seattle, and she researches, among other things, rights mobilization, international courts, and global justice institutions, with a specific focus on legal and social change processes, and including, such as here, the mobilization of non-states. And you all know Siri. She's a professor here at the University of Bergen, the founding director of Law Transform and Superwoman, as you all know. Siri is an expert in the use of law and legal institutions as a political tool and strategy for social change, and a great vision for that. They are both contributors to this mentioned book, and we'll use their findings. And there will be a good dynamic here, I think. Starting with a presentation from Rachel. Yes, and then after. I don't really need notes to myself, but I have notes. So I'm Hege Stein Helland. I'm a postdoctoral fellow at the University of Bergen, and I live in
Okay, this is classic last day of the exchanges, in that you go from contributing sort of a limited 3 to 5 minutes to now you've got 15. So this is a bit on the fly, and we're going to have fun. I can't tell you how much this previous panel just laid the groundwork even better. So I've got just a short presentation to show some data to get that conversation going. I think this is going to be a perfect panel to sort of bring together the lawyers in the room, the social scientists in the room, and see if we can put our heads together to try to figure out this dynamic a bit more. So I'm going to, in some ways, put these, it's really nice. Again, you got this, very concrete background on the Norwegian cases in this children's rights area. I'm going to step back and go a little bit big with it, and then we'll come back to it within this presentation. I also sort of want to, in terms of thinking about the panel, and this is harkening back to our very eloquent annual lecture given by Catalina the other day, and enable us to return to that conversation, right, and try to figure out where we are. in terms of, is this backlash? Is this, counter movements, or is it, as I want to say, legal mobilization as usual? And you'll start to see what I'm thinking, but I hope we have a robust conversation. So let me keep moving so that we'll have time. So as some of you might have heard on the research methods panel yesterday, I have a large database and data collection project that involves the European Court of Human Rights. This is over a 60-year period. We've coded all judgments. And one thing in particular, besides just general descriptors, I've been very interested in who's participating in this in terms of interest and advocacy organizations. So really looking at the role of organizations. In the Norwegian children's rights cases, there are organizations and individuals putting forth and advocating particular interests. And so that issue area is a really interesting issue area to look at. But I wanted to start with the larger data so you could see some of the trends. I do show the kind of whole, a longer time period. These earlier high spikes, you can almost ignore. There was so few decisions by the court in those pre-1998 years, right, before Protocol 11, that those high spikes, these represent when there is participation found in these judgments, right? And so there's fewer judgments. So if you see even one or two forms of participation, it looks quite dramatic. But let's just pay attention to this 1998 and on, and you see this upward trajectory. These are the lines denote different types of participation. An organization could be an applicant. They could bring a claim themselves. They also could serve as legal representation, the dotted line. And finally, and this is what I'm going to talk more about, and is particularly relevant to the children's rights cases in Norway, is the amicus curiae, so the briefs, third-party interventions, in which an organization files a brief and becomes part of that conversation, as maybe I'd call it, or dialogue even, that is the decision itself. So that line, as you can see, is very much on the uptick. So when I started this research quite a while ago, that's exactly in some ways what I would have expected. And it's certainly coming true. So there's the larger, again, context of participation. What types of groups are actually involved in this? And so this is just kind of the top 15. There's about 21 now. And so these, again, by types, I mean, what types of organizations are participating at this court and again, by participation, I mean, are they filing briefs? Are they serving as legal representation? The bars denote, you can see the different coloring to show this lets us know, yes, not surprisingly, rights organizations are the most active participation. But as I mentioned yesterday, corporations are the second most active participant. And again, it shows you with businesses, they are applicants, they are bringing direct claims. Whereas a rights organization, we see it's split between them serving as legal representation mostly, but also they very much are very active in terms of bringing amicus curiae. Likewise, you'll see religious organizations, and I'm going to be talking about them more specifically, are also right up there in terms of their active participation. If we look at, so now we're turning just to this third-party intervention mechanism and organizations being participatory in this way. And this longitudinal bar graph just gives you a sense of, if we build it, they will come. If access begins to open up, and it has, and this, I mean, I'll talk further in Q&A, and I'm happy to. This is where I see this as an opportunity, a mutually constitutive process by which agency, meaning these organizations, demand access. Remember, in the beginning, there wasn't this type of access. This was not spelled out in the original treaties. It's something that evolved over time. And so as that court had its door knocked on, and the court itself, through its case law in the 70s, began to expand that, it later was codified by states. And even that over time has come to evolve to this space where, we had maybe labor union or human rights organizations in many degrees. And then in these time periods, we have 21 different types of organizations. So again, this is the number of interventions, briefs, third-party interventions taking place in these judgments. So, and just this year, right, in March, the court again sort of issued a refinement of the rules around third-party intervention. So we see this, the structure itself, the institution itself beginning to change, right, due to this mobilization. I want to point out a particular group, and so maybe this is about this conversation about counter mobilization, and I'm also now getting closer to talking about the Norwegian cases, so that we can continue our conversation here. But if we want to think of religious organizations, in some of these cases, it's being a counter movement or a backlash. That could be one way to think of their action. It also could just, again, be, this is politics, right? We've opened this institution, which is handling very, I think this last panel stated it so clearly in many of these panelists, issues like margin of appreciation, discretion, the kind of, what would you say, these sort of vague treaties that say, the best interest of the child, all of those become political opportunity structures, right? In some ways. And so then it's not surprising that if you want to be a part of defining what the best interest of the child is, or when margin of appreciation should be used, well, then you're going to want to show up here and you're going to be wanting to submit a brief. And so that's somewhat what we start to see happening. I think it becomes fascinating empirical question to say, well, when do they and when don't they, right? And that's what we can begin to study when we have the patterns. But nonetheless, I wanted to point out what religious organizations have started to do. So churches, congregations, religious leaders, faith-based advocates groups have all been, there's evidence of them participating in these different ways. So they often are protecting their religious interests. So even, that sort of, kind of right to the freedom of religious and conscience, that type of article. But they also are intervening in other social issue areas, sort of stating a particular position that maybe is seen as, conservative and holding up a particular set of values associated with that religious organization. I want to mention a couple repeat players, right? Because we talk about this transnational action and who's actually behind these data points, right? And so those become the really interesting questions to try to map it out, right? And when you do that process tracing, you start seeing this. So these are two sort of, kind of Christian legal advocacy groups. They have their origins in US foundations and groups and organizations. These two have appeared and are quite active before the court. And in particular, it's worth mentioning that dig a little deeper and there's a particular lawyer, Jay Cichowski, who was behind both of these organizations and actually served on Trump's legal team. And so you start to begin to trace some of the kind of spread, the network that exists and the ways in which we have these transnational actors who can end up mobilizing some of these similar causes, but then in different institutions globally. Okay, let's turn to Norway, and I'm gonna wrap up here with my spiel to kind of bring it back around. So certainly, I just want to talk a little bit about these child's rights cases and the sort of I think that, again, this last panel did a great job of showing some of the legal nuances that are going on in terms of both the international law that's getting pulled into even, and is sitting there side by side with the European Convention, and some of the areas then that are left that are, these avenues for trying to figure out how to balance these rights and interests and what does the state then do? It is also definitely couched in a larger, this is where the politics is, right? some of you might have, I'm sure you heard and met, and if you've been here all week, Maria Pavlova, who studies Russian politics and Central and Eastern Europe. And as we started talking about these cases, because she didn't realize I was working on them, she's like, she's Bulgarian and spent the first 18 years of her life there. And even way back when, the Norwegian, child protective services was like the boogeyman in the night. If you didn't go to bed on time, they're going to come get you, right? This whole narrative of sort of stealing children. And so these court cases are actually set within a larger sort of mobilization of, even this sort of anti-Western or anti, kind of rest of Europe that Russia continues to kind of propagate. So we can't help but, we have to pay attention to that too, right? There's a larger politics that is around it. And so again, this case, which is particularly, and I just want to tie this up with those third-party interventions. This case was mentioned in the last panel. What's quite interesting about it, it had 11 different interveners in it. And those interveners were, they were states. And these three I've put up here just because beyond that case, they are very active in these Norwegian children's rights cases alone. But states were involved in that as third-party interveners. So in the Stein case, there was Belgium, the Czech Republic, Denmark, Italy, Slovakia, the UK, and then you also had ADF International, which I just talked about, AIMMF, the AIR Center, and also the adoptive parents, right? So there's a whole interesting dynamic, and I can talk more about that in Q&A of who these third-party interveners are. And in this child welfare cases, you're really getting I think it's a great microcosm of the many different actors that do end up submitting. So the Czech Republic, Slovakia, and then this Polish institution. And you can see here from the second paragraph, you get a feel for what it is, what they represent ideologically, but they've been very active in issues to do with the family and family values and keeping children with biological parents, and really that as a standard is very important. And they also have been involved in other social issue areas. I'm going to end with that. I wanted to just share some of the data, share some of the politics. I think we should have a more robust conversation about those. And certainly we've got these experts right here in the room on the Norwegian children's rights cases, which I think become this interesting microcosm for, connecting up the domestic and the international in terms of legal mobilization. And there's plenty more, in this direction in the future. All right. Thank you.
Very, very interesting. And I have to say, as an editor, I'm looking forward to reading your book chapter because this sounds fun. So, Siva, you're now going to comment.
I follow up. So, unfortunately, I've done some remote for reasons couldn't come. And those of you who told me before know that these people who actually are for a very long time done research on these networks. These conservative networks has been placing government and different types of actors and so involved in many. But you gave, this was so brilliant, and it gave another perspective into the same. And I continue, and I can just tell you that he has published, and others as well, but he has published a lot on this. There's also a documentary made on the basis of some of his work. And I first started working with him, and obviously Rachel years, around the sort of abortion welfare project, with such a reproductive rights for the Backlist project a decade ago. And then actually, I went to the webpage of all the years, because he talked about it. So I did, and I realized that I didn't only deal with abortion and LGBT issues, it dealt with the Norwegian Child Protection Services. And it was like one of their big issues. So then actually Maud and I, that's one of the origins of this project, because we realized that our research agendas converged on this. And so Neil is a key Neil in this. So I think that this is something that is super interesting. So the question of why does this a Catholic organization, why is it so interesting? Why so many things interesting? I actually didn't know what you were saying just now, that Maria Popova said that this the sort of Norwegian Child Protection Services as a boogeyman was so far back. That is actually really interesting, because it is further back than I actually thought from the author. She's young. So it's part of it. So it's a cultural thing, and there are many different explanations that lead together in this. So first of all, there are many. We're discussing what is it that brings these cases to the court. And I just want to sort of, for those who went in the formal discussion, sum up a little bit of this. So of course, they come to the court because parents are desperate, because they're upset, because there's somebody has taken away their children and they don't get to meet them as often as they should. So there is a sort of existential concern in these cases. Many of them are sort of Norwegian origin, some are of foreign origin. And as always, there are a lot of stories constructed about why they are targeted in this particular way. And some of it will be true, some of it might not be sort of objectively the case. But of course, this individual reason for bringing the cases is really, really important. And if there are legal opportunities for bringing cases, is very easy. So you don't have to pay anything in these cases. I mean, legal access is very difficult in Norway generally, expensive, but in these cases it's not. So you can bring the case at all levels, and you don't have to pay. So in a way, you don't need an additional explanation. It's easy to bring the cases. The parents have a very good reason for bringing the cases. So that is an important part of the story. Why the cases come, but we also know that there is this interest. And in many cases, it's probably sort of jumping onto cases that already are there more than stimulating cases. There is also, I mean, some of these, the cases that concern families who are part of religious groups, part of congregations, for instance, Pentecostal congregations, and then that has led to mobilization globally on some of these issues, and some are concerning other foreign nationals where you also had this mobilization, for example, in India. So, and of course, you have this asymmetry where the government can't, and the Child Protection Services can't tell why the case is taken away. So it's only the parent story that gets into the media, and then it becomes complicated. Always, everywhere in this case. So there is this aspect which isn't organized mobilization. So and that is important, because it's important that this doesn't become like the big conspiracy. And then as we heard, as you said, I mean, of course there are problems with the Norwegian Child Protection Services, and of course there are things that can be done. But as Malik usually also shows, I mean, objective indicators show that the Norwegian Child Protection Service is actually quite good comparatively speaking. So I mean, it's not that Norway is worse than other countries on objective terms, but there are reasons why the cases. And of course, once one case succeeds, that also brings other cases. So there are all these dynamics that we know from others. So that's an important part of the story. But then it is the question of why is this such a target for that sort of organized ideological part that we see and that comes so clearly in these cases. And again, going back to the former panel, of course, one of the things that is interesting is that the best interest of the child-centric nature of the child protection services is very strong in Scandinavia and in Norway. which means that ideologically it sort of puts the child at the center and the parents and the family not so much. It's and it's partly linked to a very sort of also a trust in the state and all, and a way of looking at rights as an obligation of the state to provide more than an individual right to go to court. So it's sort of a different way of thinking about rights. It's in much more substantive terms, and also as we trust the state. The state is us collectively, and we will sort of step in to take care of the objective interests of the child. So there is this. So, and that's a very different way of looking at the state from what you find in many other parts of the world, in most other parts of the world. So I think that the reason why this child-centric notion is so strong and so sort of important for the child protection services is also because we trust the state in a different way. And so I think that is also what is sort of this state feminism that is characterizing in a way, at least, and that's what it's sometimes termed. I think that we can embrace it, but I also think it's also used as an accusation. Is some of what is ideologically a threat to the natural place of the family in society as the core institution, which is so central to many of these organizations, which is also why gender ideology becomes the big threat. So it disturbs the natural order of things. It disturbs the role of the family and society, the gender order, where the child protection services guided in this particular way, sort of focusing on the rights of the child, becomes so problematic. So I think that is the big. That's one of the reasons why I'm saying it's, and it's actually also starting. It's if we look at campaigns, it's also Sweden, and we see that there are also organizations and actors from Russia who is also sort of active in relation to this. So it is sort of another way of mirroring these larger ideological fronts that we're seeing and that are sort of playing out on this field as well. And we see that if we sort of, it's you said that there are states intervening, and actually it's very uncommon that states intervenes against another state unless you have one of your citizens involved. So here we have states just free floating, intervening on these issues and repeatedly, which is also very unusual. So sort of showing that it's playing out in a very unusual way in the European Union of human rights, which is also interesting. And one more thing, so and that was surprising to me, but so the European Court of Human Rights obviously has the European Convention of Human Rights as the legal basis, not the Convention on the Rights of the Child, which means that the children are, of course, protected by the European Convention of Human Rights, but not in this particular way, which also means that it becomes a good arena for contesting parents' rights and sort of different ways of understanding also the rights of the child as sort of the right to be in the family. So maybe I'll just stop there, but hopefully just bring some additional perspective. Okay.
Yeah, it's just we actually have a chapter also in the book addressing this
Yes,
issue on
yes.
And he has found that the only issue that has attracted this much attention in terms of third-party interventions and is Ukraine versus Russia cases. So that kind of sets sets it in an interesting comparison there. I think we're just going to open the floor for questions. Thinking there is many box. We have the box. First thing there.
Questions and comments.
Yeah. Should we have collective questions or?
Collect some and then we'll see.
Hi, thank you for absolutely fabulous set of presentations. So the one thing, and Siri, you raised this in a way by talking about the nature of the Norwegian state. And so what I wonder too, and it correlates with the, of course, rise in opening up interventions, etc. And I'm not quite sure those connect, but in a way, Norway, maybe Sweden, are the last remaining effective welfare states. So in terms of the kind of whole neoliberal push and tied in with the more conservative issues around the world, these become the points of attack. If we're going to suggest that we should once again have some form of state in the world that isn't neoliberal, these are the models that still exist. With all the problems they might have, right? But they still exist as models. And so I wonder how much this is also driving some of this against and that ties in with the libertarian notions of this is the overweening state, right? This is the dominant state. And it becomes even more interesting when we start saying, well, is this a feminist state? Another reason why the patriarchy may not be happy.
Right.
Absolutely. Absolutely.
Hi. Well, thank you for all these conversations. I do have some additional questions about the data you presented, okay? Because I think it was very, it made me think about different things that you can think about those that you presented. Your second slide was about organizations and have they changed throughout time? That is, have you crossed it with a timeline? Whether, for example, at the very beginning, the representation or the presence of rights organizations was stronger than business organizations or whatever. I don't know. I mean, and the other thing, again, whether the ideological orientation of the claims change according to the type of organizations that were starting to appear, and whether the ideological claims change, whether you were using or the amicus curiae started to grow, and because it implies a more sophisticated type of use of the mechanism than when the direct applicant was the one that was making the claims, or I wrote some other type of type of representation and ideological orientation, organizations and ideological orientation, and change of claim throughout time. I'm just asking these questions because of the title of your presentation, but I'm sure that given the size of your database that you mentioned, you're able to answer all these questions.
Okay, thank you. This is a great presentation. Thank you, Hege and Rachel and Siri. Yeah, there's tons of things to talk about, but I will kind of limit myself to two topics. The one is, Rachel, I was just wondering, do you have any kind of knowledge, research on the impact of these third-party interventions? Impacts on the court, of course, and the decisions made there, but also kind of impact on kind of other areas in this. Yeah, kind of, I like the way you showed that that this, when you open up the door, there will be a kind of people go in the door. So lovely to show that. And the second one is, and thank you, Siri, also for bringing up that we have children's rights, and they are also very strong. And of course, in the and you mentioned also that the criticism is for many of the Nordic countries, which is also related to the questions here on the welfare state and this kind of social democratic welfare state model. But also for Norway and for Sweden, the convention is law. It is part of it on the same status as the constitution, which is kind of really important in itself. And then I think I want to emphasize that there is a real conflict in child protection cases. Yep. There's a real conflict between parental rights and child rights, which is kind of, I don't think that the European Court of Human Rights has properly, and I think that was also kind of what you said, Siri, haven't properly taken a kind of explicitly a stand on. And we can see that in some of those principles it has, where you have, you should always aim for reunification. De facto, at the same time, you should also protect the de facto family. So you have some legal protection of the foster family, for example. Yeah, so there is kind of some very clear conflicts in the court's behavior. So I will just stop there, but these are the two topics I would like to hear more about.
Yeah.
Thank you.
I was just wondering about how developed is the strategies, how comprehensive are the strategies? They kind of take their lessons from the US. That's my view on it, that where you can see how they have strategies going far back in time, the Federalist Society, but also, for instance, Alliance Defending Freedom, which had this case before the Supreme Court, Smith versus, I don't know, nobody, it lacked standing, but was this web designer that could deny gay couples services on the merits of free speech, which was weird, but but we kind of get our lessons from there, and this escalation of third-party interventions and this escalation of activities directed at the court, isn't that kind of, doesn't that show something about a battle for a legal culture that is, and how comprehensive is it? Do they go plaintiff hunting, for instance? Like, yeah.
Do we get another 45 minutes? I think we have really good topics here to talk about.
I mean, I did. I am done.
It's the last day. All things happen here, right? No, let me quickly try to address some of these. These are excellent questions. And I'm excited to say, again, as I continue to work on this database, I do think a lot of these answers are in there. And it's just about, and that's part of the idea. And I talked about this yesterday, is to share that so other folks can go down whatever route they're interested in. Catalina, let me just follow up with you that, yes. So, that is very, you can analyze that. And what I do find, right. So again, there in the sort of, earlier years, the type of organization that's there is, a trade union or a human rights organization, and the role that they're playing, and again, let's just take this for third party intervention. They're providing comparative data, of the domestic level for other international law and information. So sort of bringing research and that true friend of the court role in its purest sense. And again, remember, this is still up to the discretion of the president of the court to decide whether they want to allow that third party brief. And that's very different than, the US system where, everybody gets in there and there's 200 sitting there that, may or may not make a difference. So what's shifted over time? And even when I did interviews with judges in 2015, they talked about just the different styles of judges and whether when they, then you could see which presidents allowed it or not. So part of it was the information that was in the briefs. Part of it was whether judges who came from legal academic backgrounds welcomed more data. They welcomed more information. Yes, it made the stack a little bigger, but other judges who were less used to using, or doing more legal research were less likely to allow those briefs. But then what I even heard at that stage back in 2015, and now we're seeing this shift, is so they had mentioned, I talked about it was child custody cases, but between parents, not a child welfare system. And they would say we always welcomed the other parent who maybe wouldn't otherwise be in part of those proceedings. But they said we've also seen sometimes there's religious organizations who have ideological ideas, and they weren't allowing. They were actually denying the briefs access. So already sort of showing that no, this if you're going to actually help us, we'll let you in. I think that's starting to change, and that might be, again, this is the question I want to throw back to you all, is sort of like, are these institutions more democratic if we open them to everyone and all the different voices and all the different roles that those briefs might play? But that's a distinct shift that I am now really seeing, because in these cases we're seeing the Ordos Institute, they just submit the exact same brief. I mean, that's very American style. Like, they're not even rewriting it. It's the exact same brief with their statement of the biological family is most important. And so they're not really adding to the courts. They're not really helping. So that's a distinct shift. I could keep answering. I don't want to. Impact. Yes. So part of what we study, and again, this is why I love international courts. There's often another database that helps you trace some of the impacts. So we've looked at, certainly you can take these cases, look at cases that have organizations in them. One thing we've done is just even try to trace the way, the briefs are used in the judgment when the court is actually, and there are cases where you see, when rape is understood as a form of domestic violence, that you know, or domestic violence is a form of discrimination, how to understand that. Some of that is sharing coming from other courts, and that sharing comes through a brief, and you see the court citing that. So that's one way that you can see impact. But also then these domestic level changes, right? When general measures are taken at the domestic level. But this process tracing that I think, you know, again, this edited volume, I'm sitting there taking copious notes from this first panel because, you know, when you're doing the interview on the street level saying, how have these impacted, you know, there's some of your impact. So that certainly is a way that you're seeing. Oh, and then this question about, you know, legal strategies. Yeah, I mean, this is, you know, in the literature, the kind of socially legal, public law, political science literature, even this sort of spread of adversarial legalism, even this American style using courts as sites for politics. We've seen, you know, again, as constitutional courts were created, as judicial review expanded, we see those same kind of strategies evolving. And, you know, I have an earlier book on the EU's supranational legal system, and looking at the ways that environmental groups and women's rights organizations began using that supranational court in a very strategic way, in which some of the most important decisions in the 70s, the Defrenne decisions, which were very important to women's rights, coming out of Belgium, was a labor lawyer searching around for that perfect litigant. And so, you know, we're watching this happen again. And I think, again, that I want to throw it back out, the normative. Is this good or bad in terms of the amicus? Because, you know, the American style is here comes everybody. And then you kind of wonder if those are all ending up in the waste in some ways too, right? That, you know, because if they're no longer really being helped to the court. So anyhow, I'll leave it there.
Yeah. No, this is super, super, super interesting. I'm just going to continue on somebody sort of speaking to maybe particularly Hans and Asker. So the title of the project, but this is part of, is Legitimacy Challenges, the Normative Foundation of the Office. And it is exactly this sort of larger context. There's child protection services are, of course, child welfare is an important part of the welfare state, and this is an ideological challenge. So that is very much in the cards. And I was part of we had an earlier project called Juridification and Social Citizenship, because the Norwegian welfare state has been changing in a much more neoliberal way, where over time it's become much more contractual, a lot. So from somebody said that yesterday or at some point, saying that when I was a child, no, it was actually one of the party leaders. I was watching television when I came back yesterday. said that when I was a child, my mother became a single mother when I was 3, and there were obviously no children, and the child protection services were like, what do you need? How can we help you? How can we create something around you? But now it's much more like, do you check, like, do you fit in? It's much more contractual. You have, it's like, and this also has to do with a lot of things. I mean, it's way too much to go into, but that has some implications, because it also so in Norway, the right to health, the right to education, the right to social services was never the right to go to court. It was always the right to get what you needed. But that has changed, and for many different reasons. Also because the way the state's been structured, but and these are global influences. But it's also, of course, the rise of rights, and the fact, as we heard, the European Convention on Human Rights and other conventions are part now of Norwegian legal system, which means that the Norwegian Supreme Court is not the Supreme Court. It's just like an intermediate court, and you can go on. And it also means that legal mobilization makes a lot more sense, both at the individual level, but also for organizations. So all of this is making sort of the push from below a lot stronger. So yes, I think that there are also, so what we're been discussing and thinking is that it's not necessarily very different in the sense that you push the cases because they're coming, but you latch onto them. And also that those who go see who the lawyers are and who the people are who have the strongest, you can help them. So it's not necessarily at least sort of a way of sort of going hunting, but it's sort of processes that meet each other in an interesting way. But so I think it is sort of definitely a changing legal culture, and some people obviously want that. It's a change in political culture. It's partly sort of more judicialization of the legal culture, of political culture. But it's the reason is it's not the reasons are many why we're seeing this. But I do think that there is also, I mean, that is also part of the ideological shift. Although I think that if you look at the conservative right in the US, it's much more capitalist, if you want. It's much more sort of on individual rights, on the role of sort of rolling back the state than what you see, for instance, in Eastern Europe. What you see in Eastern Europe is a lot more, and also here, it's a lot more welfarist, but in maybe a different way. So it's sort of sharing the ideology around family and society, but there are some differences that we see.
Thank you. I think I'm not entirely sure what the time frame
Yeah,
is anymore, but I think we are approaching somewhat of an end here.
Yes.
Thank you so much, Rachel and Siri. This was excellent. So
Thank you all.